Good afternoon to you. Thank you so much for joining us here on Nationwide at 5. It's time for the cover story. I'm Ricardo Brooks.
And I'm Chevon Campbell.
Good afternoon to you listeners if you're joining us on radio. Good afternoon to you if you're joining us on the app. And hello to you if you're joining us on YouTube. This very busy Thursday afternoon. Major news happening in the United States, of course. Donald Trump found guilty, now a convicted felon, guilty of 34 counts of falsifying business records. Here in Jamaica, the Supreme Court has rejected a habeas corpus application filed on behalf of incarcerated dancehall star Vybz Kartel. And of course, Cabinet Minister in Andrew Holness's government, Matthew Samuda, revealing he's a British citizen, but he intends to renounce that. So, we're going to start at the Supreme Court. Yes, it has rejected an application from Vybz Kartel and two of his co-accused, Shawn Campbell and Andrea St. John, to be released from prison. The men's attorneys had filed an application for a writ of habeas corpus seeking their release. This after the UK-based Privy Council overturned their 2014 convictions for the murder of Clive Lizard Williams.
But in a ruling delivered to a packed courtroom on Thursday afternoon, Justice Andrea Thomas rejected the application. The judge took into consideration the Constitution and the Corrections Act. In coming to her decision, she determined that the detention of Kartel, whose given name is Adijah Palmer, Shawn Campbell, and Andrea St. John did not violate the Jamaican Constitution.
The judge ruled the case was not a proper one for an application for habeas corpus. She told the court that there was lawful and justified reason presented for the men to remain in custody. Now, Justice Thomas also held that while the convictions of the men had indeed been set aside by the Privy Council, no acquittal had occurred.
She held that their murder charges remain, and the judge found that as long as the murder charge remains, it cannot be said that the failure to release the men was an unlawful act. Justice Thomas ruled that the men can only be released on the order of the Court of Appeal.
Now, of course, listeners, as you recall, the Court of Appeal is to begin hearing arguments on June 10 to decide whether the men should again stand trial for Clive Williams' murder or be set free. Now, Kartel's fans wept in the precincts of the Supreme Court as it became clear that their dancehall star would not be released from prison. Amid a heavy security presence, the rowdy crowd started chanting for him to be released.
What about him? What were you expecting to happen today?
Now, if you were on YouTube, of course, you could see the videos there of the fans gathered in the precincts of the Supreme Court, some hugging and crying, and, of course, that now familiar chant, "Free World Boss." Now, Robian Williams was at the Supreme Court for all of it. Good afternoon, Roby.
Good afternoon, Ricardo. Afternoon, Chevon, to our listeners or viewers.
So, take us to, let's go inside the courtroom first. You were in courtroom 9 at the start.
First,
Yes.
initially we were in courtroom 9, but that courtroom, as it relates to space, limited space, I was standing. I took the decision to go there a little bit earlier than 2. I got there by 1:45 thereabout. When I went into the courtroom, there were no seats available for media, for lawyers. The courtroom was full to capacity.
Who? With who?
Uninterested parties, of course. You have,
Uninterested.
yeah, man. You know, you have interested parties in the matter. Uninterested parties, lawyers who wanted to hear the ruling for themselves, court clerks, other people. the room was full.
Yes.
And then we moved. We got the permission to move to courtroom 1, which is a bigger space. And the matter started approximately 2:31. And the ruling came. The judge, Justice Andrea Thomas, she gave a detailed explanation as relates to her reasons. She looked at previous cases of similar nature in coming to her decision. She started by looking at the Privy Council's decision in March,
Yes,
as it relates to their convictions being overturned. And then she started giving her reasons. She says that the convictions being overturned, it doesn't translate into an order for the men to be released.
Yes.
Yes, the appeal, she said, will not be finished until the Court of Appeal or a local Court of Appeal makes a decision into the matter.
And of course, that's set for June 10.
Indeed, and she pointed out that until that decision, the men are charged and they shall remain in custody.
This was a high-stakes effort by Isaac Buchanan, a writ of habeas corpus. And I know my friends who are attorneys, they're a little bit tickled, a little bit upset with us here. So let me say it. It was an application for a writ of habeas corpus, yes? And Mr. Buchanan filed this application. What was his reaction when Justice Andrea Thomas told him, no, I will not entertain the arguments you've advanced?
I will reenact it for you.
Okay.
Thank you, madam. You have schooled me today. Can I now take my leave? And he left the courtroom just like that. The court was still in session because the judge was still seated, and he left the courtroom. We came out of the courtroom. We didn't see him. I think another media house caught him leaving the vicinity.
Normally with these writs, the defendant, in this case Mr. Palmer, would be present in the court, but I understand he was not. Was a reason explained?
The DSP in charge of the Supreme Court, he did say that it was not required for him to be there. So he wasn't there, but his fans thought he was there, so they converged at the gate, and when they saw the truck, the truck that is used to transport the defendants, when they saw the truck, that's when they started chanting "Free World Boss," and they were waving to the truck as though he was there, but he was not. He was not in court, neither his two co-accused.
And let me just go back to that exchange between Isaac Buchanan and the judge. You're saying the judge was still seated on the bench when he requested leave to leave the courtroom, because usually, listeners, in these matters, the judge delivers the ruling, the parties stand, the judge exits the courtroom, and that's when everybody else leaves. You're saying he left before she exited the bench.
He did so, indeed. It was a little bit strange. Because, as you said, normally we would be seated, and when the judge is leaving, then everyone would leave the courtroom. Not saying that I know, because there are times when you have other matters
That
as
you have to attend
attorney
to, yes.
that you have to attend to.
Did he indicate that he had something
He did
else?
not. His response was brief. He said thank you as it relates to not attaching any cost to the application, because there were no cost attached. And then he said, thank you for schooling me, madam, today. And he asked to take his leave.
And she granted that leave?
She granted the leave, and he left the courtroom before we all went out.
Could you read his facial expression while he was leaving?
His facial expression, we could not see it, because we were seated behind him, and we weren't able to see his facial expression. But his response was very brief, and he fled the courtroom.
Well, we're getting the signal to wrap up, but before we go, Roby, just to say what is next on this cartel matter, because this is not the end of it.
June 10, the Court of Appeal will hear submissions as it relates to the matter for retrial or against retrial. The Court of Appeal will take submissions from both attorneys representing the defendants. We can call them defendants now, or appellants rather. Yes, appellants. And she will also hear from the Attorney General as it relates to and the DPP, the interested parties as it relates to a retrial. So we await June 10. The submissions will be made, and I believe it's 5 days. Over 5 days of submissions, and there's no telling when the Court of Appeal will make its decision.
Yeah. So the news out of the Supreme Court, that application, a writ of habeas corpus, has been rejected by the Supreme Court, and just a little bit of the Latin Chevon. Chevon asked a valid question. Was Mr. Palmer present in court? He asked that question, listeners, because habeas corpus, loosely translated, means
Bringing the body,
that you have the body,
presenting.
present the body. And it's a report which can be made in a court in the event of unlawful detention or imprisonment, requesting that the court order the person's custodian, usually a prison official, to bring the prisoner to court to determine whether the detention is indeed lawful. Thank you, Roby.
Most welcome.
Now we switch over to this matter of dual citizenship, where Senator Matthew Samuda, Cabinet Minister and Senator Matthew Samuda, has started the process to renounce his British citizenship. The Senator made the declaration in a statement on Thursday. He's also calling on the President of the People's National Party and Opposition Leader Mark Golding to do the same and renounce his own British citizenship.
Senator Samuda says his move to renounce his British citizenship arose from recent conversations in the public domain. He says he's voluntarily made the decision to give up his citizenship. Mr. Samuda is calling on the opposition leader to do the same. For some reactions, we'll be joined now by Sandre Roden. Good afternoon, Sandre.
Good afternoon, Ricardo.
You sound a little bit far. Can you hear me, Sandre?
Yeah, I'm hearing you. Good afternoon.
All right. You sound a little bit distant. All right, so we're going to check the line, and sort that out. Social commentator and economist Sandra Roden. And the question now obviously arises, Chevon. What's good for the goose is good for the gander. And if the GLP has made heavy weather of the fact that the opposition leader, is somehow unworthy, right, to hold leadership, to occupy positions of leadership, the logical question is, does that argument still hold currency? It is still a potent argument now that we have this information that a cabinet minister is also a British citizenship or a British citizen.
But I think it still comes down to those who are on the fence on the matter as to whether it is a moral concern or a ethical and legal concern.
Right.
And I don't know if it dies or more it takes on a new color to it to see how many members of either house or how many people aspiring to either the Senate or the House of Representatives do hold these dual citizenships, and will they be willing to come forward and state as such and renounce it? So I don't think it kills the debate. I think it now takes on new
urgency.
Not necessarily new urgency, but a new scope to see, will this now compel the Jamaican people, as we are currently going through the constitutional reform process, to give this a proper look in terms of the matter of the Commonwealth citizens, the dual citizen, should they be allowed to sit in Parliament?
And of course, that legal question raised by Abe Dabdub would apply as well to Matthew Samuda, whether he's under allegiance. He's taken the decision, he's going to renounce it. He wants his only loyalty to be to Jamaica. What will Mr. Golding do? Sandra Roden?
Yes, I'm here with you now.
Yes, man, much better. How do you see this matter now that we're learning that Senator Matthew Samuda is going to renounce his dual citizenship? Does this put more pressure on opposition leader Mark Golding to do the same?
Well, it definitely does, in the public conversation, put more pressure on the leader of the opposition. I don't know if it was the best move, because I think it's the flip side of a coin, because there can be implications or the perception on both sides. One perception could be, we pointed at one particular person and now there's somebody else. But the only difference is the leader of opposition is the leader of the opposition, and in the next elections he would be vying for prime minister, while Senator Matthew Samuda would be a senator and Mark Golding was a senator. So, there are parallels to be drawn.
But so it sounds like to your mind there's a distinction because Mr. Golding is seeking the highest office, the highest political office.
I think that distinction comes up because we're now in a state where the conversation was put out there by the leader of the opposition, because he said we don't want to have one foot in and one foot out. And I think that's where this whole citizenship conversation started.
Right.
And it's a part of the constitutional reform. We've been talking about it. Both sides are open to having dual citizens in Parliament. But of course, we go back to the 2007 court cases, etc., looking at those who had U.S. citizenship. and not necessarily Commonwealth citizenship. So now it becomes muddy because of that.
Do you think this matter then must now go to the court for an ultimate settlement as to the nature of this matter of renouncing citizenship by, or I should say, essentially pledging allegiance through this matter of renewing a passport? Do you think now the court needs to be the arbiter and come with a final decision?
I honestly don't think so, because the Commonwealth being what the legal representation in the Constitution about citizenship was based on when our Constitution was written and how it came into force. Now, it's legal. There's nothing wrong with it, but it's just based on how our Constitution came into force. If it is a case of a decision can be made without the court, it is, to my knowledge, it is a decision of not just the parliamentarians, but the Constitution going forward to decide if it's a case that we want this. And since everything is going to a referendum, I think the people should also have a say on it.
And further to that, there was a comment by Mr. Golding that he would await for a debate and the people's thoughts as to whether he should retain that citizenship, and if it is required that he has to renounce it at the end of that debate from the people of Jamaica, he will do so. Whereas Senator Samuda has simply looked at what's been said in the public domain and of his own recognizance decided that, no, I'm just going to give it up, I'm going to renounce it. Do you think Mr. Golding should stand on that same principle and hold onto the citizenship and give the people an avenue to decide that, or do you think he should just preemptively rid himself of it?
Why wait for debate is the question we really should ask, because the opportunity is there to make that decision now. I think people will take the leader of the opposition seriously if it's the case that he renounces his citizenship. That is just a fact, because of how muddy and political his own citizenship has become. He now has the right and remit to make a decision that he thinks is in his best interest. But the thing about it is that political leaders, their personal lives normally become a part of the political conversation, especially when they're in the highest offices. He's in one of the highest offices in the country. And based on that, he now has to show if he decides to wait on that public debate, that's his decision. But I think people who are questioning what's happening, like even my own family members who ask me, what's really happening, because it looks really muddy in the media, he can make that decision. And then I think people would see that he actually has that commitment to Jamaica. And that's what the conversation isn't about the legality. It's about commitment. It's about an ethical conversation. That's what people really are talking about. Like, if you want to be the leader, why would you not solely, have allegiance to us? That's what I'm hearing.
Right. And I hear the distinction you're making, and I understand the distinction. Those seeking the highest office, their call is great, and I get that. But in terms of how potent the political message from the JLP is, yes, Matthew Samuda is renouncing, but do you feel that message has been blunted, that they can still credibly go after Mr. Golding on this matter of citizenship, now that we know that there is at least one person in the JLP who has held dual Jamaican British citizenship?
Well, I think they still can, because the conversation is deeply political on the premise that it is now a JLP versus PMP issue. So, seeing that Senator Matthew Samuda would have publicly come out and say, listen, I'm renouncing mine just based on conversation, you also have to remember that he plans to vie for a seat, as in the lower house. And I'm guessing based on that, he now has a decision to make, because yes, he could have entered with his British citizenship and gone in and become MP if he were to win for Northeastern term. But if he renounces his citizenship and enters Parliament, then I think people will take him more seriously, not just as a member of Parliament, but he serves in the executive as a minister. And that is a good statement to the people, since as we're having that dual citizenship conversation now. The conversation wasn't up before as it relates to Commonwealth citizens, but it came up based on our constitutional reform. And that is where it becomes a matter for people to question, because a lot of people were not really educated that this is already a part of our constitution.
30 seconds. Does the matter of descent matter? Does it matter whether the person was born with the dual citizenship or had taken up the dual citizenship at a later date? Is that pertinent to the conversation?
Yeah, it is, but legally it doesn't matter. But from the ethical and the citizen allegiance concept that people may have, it may matter to them, because somebody will say, why did you take it up later? Why did you go overseas and decide that you wanted to? Now, some people may not care, but some people may care. So if it is that, you want to serve all citizens, then the views, the converging views must be considered. And of course, based on the fact that you're leading the country, a conversation will always be there. Now, if they are born with it or born into the citizenship, there's nothing they can do about that until they come to an age where they say, listen, I want to renounce this. And that is their decision to make.
All right, Andrea Roden, economist, social commentator. Thank you so much for your time.
No problem. Thank you, Ricardo. Thank you to your listeners.
And just before we go, we have a media release from the Office of the Director of Public Prosecutions. Let me just read it quickly for you, listeners. The DPP's office says an application for writ of habeas corpus was filed on May 17 on behalf of the applicants, Adijah Palmer, Shawn, Campbell, and Andre St. John, and was heard in the Home Circuit Court today. The court ruled that the application, or rather the matter was heard yesterday. No, Thursday, May 29. I think there's that error. That should be Wednesday, May 29. The court ruled today that this application requesting the applicant's release is denied, and that the superintendent of the Tower Street Adult Correctional Center is acting lawfully in keeping the applicants in custody. The DPP says the court noted there is no order from any court indicating that the applicants are to be released, as the order from the Judicial Committee of the Privy Council quashing the convictions was not an order for release. The applicants are not eligible for bail pending appeal due to the offence for which they are before the court pursuant to the Bail Act. Due to the pending matter before the Court of Appeal on the issue of retrial of the substantive case, this is the extent of our updates at this time. Right? So the Office of the DPP saying that, telling you, as we have, that the writ of habeas corpus was rejected, and importantly, that the applicants are not eligible for bail pending appeal due to the offense for which they are before the court pursuant to the Bail Act. Yeah?